Hello and welcome to the special broadcast. I'm Anusha Soni. Transforming India. That's the theme and narrative that we discuss. On this platform, we'll discuss key issues pertaining to India's growth and future. Over the course of next few weeks, we'll touch upon these crucial aspects which are decisive for us to be the world leader. The growth story of India is one driven by the potential and innovation of 1 billion plus individuals, the Indians. And for any country to thrive and survive economically, it needs just the right kind of ecosystem for businesses and individuals to grow. Well, the dream of a $5 trillion economy or to be the manufacturing hub of the world, well, it's an ambitious one, but not an impossible task for our country. What does this ecosystem mean that I'm talking about? It means a hassle-free bureaucracy. It means quick and speedy resolution of disputes and carving sustainable goals of development for companies and individuals. Today, we touch upon a very crucial aspect. Judiciary plays a very important role in the system. Businesses worry about disputes with government, individuals or activists who may knock at the gates of the door for certain causes. Today, we talk about the role of judiciary and bureaucracy and also activism. Are the priorities misplaced somewhere? What is the tweaking that we require? What is the role of activism in India's growth story? Has it impeded growth in some way, like some believe, or perhaps a right balance needs to be sought? Well, joining us on the broadcast is our esteemed panel of guests. We have Mr. Ajay Dua, who's the former secretary from the Ministry of Industry and Commerce. We also have Justice Ekre Sikri, the former judge of the Supreme Court of India, Mr. Sudhir Krishna, who is the former secretary of the Urban Development Department from the Government of India, is also joining us on the broadcast. We also have Justice S.N. Dhingra, the former judge of the Delhi High Court. Thank you, gentlemen, for joining us on the broadcast and sparing your time. Justice Sikri, coming to you first and setting the narrative and tone with you. What is the role of activism when it comes to India's development story? As a key person in this ecosystem, you've dealt with multiple cases, multiple situations and scenarios. According to you, where is activism placed in this entire setup? Justice Sikri.
You see, I don't think the issue should be the narrative which you have mentioned and the role of judiciary when it comes to economic development, and you have rightly mentioned then that we are on path to economic growth, and we are already fifth largest economy in the world. We want to become third economy in largest economy in the world in next few years. So therefore, in a situation like this, or when we want and there are so many slogans which are initiated by Indian government also for make in India and making India economic power. The question is that in such cases, what is the role and what judiciary has to, in what manner judiciary should play a role?
Yes, sir.
And it may not be exactly in the context of activism, I would say. Matters come before the court and how the court should deal with those matters. Yes, to some extent, you are right. Activism comes when there are issues which are raised in respect of various projects which are launched by the government or public projects, and when the feasibility of those projects is challenged on various grounds, particularly on the ground of those projects affecting the environment or ecology of the country. And therefore, there the question comes, and these situations come before the judiciary, and judiciary has to take a particular view in such matters. So having said so, let me say, apart from this, we say that we are on the road on the road of economic growth. Apart from that, I would say that India is a country, or our constitution also talks of welfare state. So we have to talk about the welfare of the people. There we have is even today 1/3 of the population is below poverty line. We have to talk about the elevation of the poverty and economic welfare and well-being of the citizens. So for all these reasons, many welfare schemes and many infrastructure and other projects which are necessary for the economic growth of the country. And I would say, and I am of the opinion, and I have said so in one of the judgments also,
Yeah.
that when we have to have this goal of social welfareism and growth of the economy has to be achieved, all the wings of the state, be it legislature, be it executive, and be it judiciary, all have to play a very important role. And they have to work not only in tandem, but in a most efficient way, how they can work.
Yeah.
And therefore, in this process, the judicial wing, while undertaking the task of performing its judicial function, is also required to perform its role in this direction. And let me here quote only, I mean, 3, 4 lines. I'll quote, of course, from the judgment of the Supreme Court. And
Sure, sir.
incidentally, I
Sure.
was the author of that judgment.
Sure.
I say that interface between law and economics is much more relevant in today's time, when the country has ushered into the era of economic liberalization,
Yeah.
which is also termed as globalization of economy. India is on road of economic growth. It has been a developing economy for a number of decades, and all efforts are made at all levels to ensure that it becomes a fully developed economy.
Okay.
Various measures are taken in this behalf by the policymakers. The judicial wing, and that is what is relevant, and you have asked, the judicial wing, while undertaking the task of performing its judicial wing function, is also required to perform its role in that direction. It is called economic analysis of law, and or the connect between law and economics. And
Okay.
I have said here
Yeah.
that, of course, the judiciary is supposed to apply the law, but when on the application of law and while applying the law and on interpreting a particular provision, economic impact or the effect of a decision, wherever warranted, has to be kept in mind.
Absolutely. Absolutely.
Likewise, in a
Yeah.
situation where two views are possible, or wherever there is a discretion given to the court by law, the court needs to lean in favor of a particular view which subserve the economic interest of the nation.
Yeah.
Conversely, the court needs to avoid that particular outcome which has the potential to create an adverse effect on employment, growth of infrastructure, or economy, or the revenue of the state.
Okay.
So, therefore, this is what, according to me, has to be the approach.
So
And
I
yeah,
believe
sorry.
you've very succinctly summarized by reading those portions of the Supreme Court order, balancing the right concerns, economic interests, national interests that need to be taken into account. Justice S.N. Dhingra, the former judge of the Delhi High Court, is also with us on the show. Justice Dhingra, to what extent would you agree with Justice Sikri? And I also want you to shed light on the proposition that often to balance these concerns is not an easy task for the judges. You would know it firsthand. There are often conflicting narrative, conflicting interests that may be at stake. Sometimes the rights of the local people may be far more important, and the national interest may demand something else, and the corporate interest may be something else. And amidst all these conflicting interests, there's also the role of activism which comes in, various NGOs that come before the court. How does the judiciary really balance all of these concerns? And of course, we're talking all of this in the larger context of growth and development of India.
You see, the problem is not that you should not take into account the different balancing interests which come before you from the side of the executive and from the side of business and from the side of society. You must take all those into account. The problem is when an issue comes before you of this nature, you should sit on the issue for 10 years. Who is going to wait for 10 years?
Yeah.
And then decide that, oh, now you will get permission after 10 years. You see, we were in 1970, when we got freedom,
Yes, sir.
75 years have passed. We wanted fast railways. We changed from steam engine to coal engine to diesel engine to electric engine. And we converted railway lines, railway signaling system. But what changes we have made in judicial system so that even at trial court, a dispute brought for enforcement of contract is decided quickly.
Yeah.
You see, we are going at the same pace. We have no concern for the common man or for the society or for this business. We are moving at a pace so that we are not prepared to change our way of action, whether it is High Court, whether it is Trial Court, or whether it is Supreme Court. What are the priorities of Supreme Court? You hear a petition for LGBT rights or for same-sex marriage within 1 month of the filing.
Yeah.
This is your priority because it gives you publicity and now throughout the world. And you keep a petition pending for granting approval to a mining lease or balancing the rights of society in a forest where forest rights are infected of the Adivasis. Keep sitting on it for years together. I know petitions are pending in Supreme Court where balancing of Adivasi rights and business rights are pending for years together. Supreme Court has no time, High Courts have no time. See, this prioritizing, which is priority, whether it is publicity interest litigation for the Supreme Court judges,
Yeah.
or the interest which really, you see, the litigation which really affects the growth of the country.
Yeah.
The growth of country, people don't want that, you see, you should sit on, you see, the Supreme Court, see, few years back, laid down rules of clinical trial and how clinical trial will be done. Many companies, bogged by those rules, shifted their clinical trials to USA and UK. You see, consider that this country was having opportunity of having clinical trial. Are the UK and US courts not bothered about their society? They are more strict. What people want, that give decisions early. Don't sit on those decisions. Today, even you see, enforcement of a lease deed and eviction of a house takes years together, 5 years, 10 years, and this is the way judiciary is acting since beginning. We have gone from bad to worse. We have not thought how to change this scenario, how to make our rules easy, how to make our performance so that the plaints are filed in a concise manner, so that how to control the advocates, how
Justice
to limit
Dhingra,
the time for which an advocate can argue.
I apologize
and
for this
advocate
interjection.
Can keep on arguing for days.
Justice Dhingra, I apologize for this interjection,
Yes.
but I appreciate the plain speak that you're doing and how you're putting certain things on record. I'm sure Justice Sikri and others, the other gentlemen on the broadcast, Mr. Dua, and Mr. Sudhir Krishna will also have a view on this matter. But I have a follow-up question before I go to the senior bureaucrats that we have with us on the broadcast. Justice Dhingra, Article 32 or 226 under which you move a High Court, it is often said that these avenues have been used for enforcing fundamental rights of the citizens, but in many ways have also been misused. Often to raise issues, to seek publicity, the Supreme Court and the High Courts have frowned upon it. Often for various NGOs or for certain interest groups to put their own interest in form of a public interest litigation. Do you see that as a pressing concern at all, Justice Dhingra?
See, it is one of the most pressing concerns how Article 226 and Article 32 are being abused by advocates, and they at the encouragement of courts, I would say. You see, I can show you writ petitions where for recovery Article 226 has been used against the state, where a recovery suit should have been filed. Article 226 has been filed. But it is surprising to what extent these articles can be abused.
Okay.
And you see, the prioritization is the job of the High Court and Supreme Court.
That's right.
But look at what is the prioritization rules have till date. High Court or Supreme Court framed any rules in what manner, which petitions will get priority, what should be the subject matter, how much should be the amount involved, How much
Sir,
time should be given
I'm going to
for
pick up that
hearing?
word prioritization, and I'm going to take that forward to our other guest as well. Mr. Sudhir Krishna, I'm coming to you. It's not just the mining leases, one example that Justice Dhingra gave, but a lot of urban infrastructure projects often get stuck in various kind of litigations in the court. And the learned judge, the former judge also pointed out that there is a need to rightly prioritize what the court is going to take up. And a time-bound litigation has been the need of the hour. And I know that Justice Sikri and various other people have spoken about it, that how we need to set a time frame for adjudication and resolution of these disputes so that the country moves forward. It's the growth at the end of the day that we are all looking at. Mr. Sudhir Krishna.
Yes, I think as I have seen over the years,
Yeah.
I cannot put much blame on the judiciary for whatever ills we are feeling that judicial system is causing. The delays, the courts are overburdened, and a largest litigant before the court is the government.
Yep.
And often the government side has to take a review as to why the litigation is mounting and what government can do. I'll give one example.
Sure.
Of contractual disputes. In the arbitration, in the contracts, it is mentioned that any dispute will be referred to arbitration if not resolved by conciliation. Now the Arbitration Act has made it very clear that the award of the arbitrator is final and cannot be challenged on the merit. It can be challenged on the ground of bias or something, or misfeasance or malpractices, but not on the grounds of merit. But yet, all government departments without exception, when they lose the case in arbitration, you see they have moved the court. Now, if they file the matter before the court, with a senior counsel appearing on behalf of the government, it is not possible for the High Court to the very day dismiss that it is not admissible. It will be taken up and it will add to the piling of the case. And it is not merely the case which are piling up. It is that the person who has to get benefit of the arbitration award, he has to wait for a long time to get the benefit which award ultimately he may win. And in most cases, the arbitration awards are upheld by the court because the law says that the court will not go into the merit of the award. But in this period, many contractors perish. Because they cannot sustain the delay, they cannot handle they have taken loan from market to proceed. This is one example. The second example is the government's own employees cases, and you see the administrative tribunals are proliferating. It is very painful to see a big advertisement that a new bench of the administrative tribunal is being opened. Government's employees litigating against the government for their service matters. Is it a good symbol? Is it a good sign? Can the government not resolve its own employees' matters quickly by itself? Why should it force the employees to go to... And it is possible. I have experimented as to how to reduce the administrative tribunal cases pending before the court. Thirdly, when a case award is made, any judgment made, I'll give a small example.
Sure.
Before the district discom, I mean the electricity company, the electricity company takes security deposit from the consumers. They are big consumers, small consumers. Now the consumers say that all right, you give me interest on the deposit. In one case, and the company will refuse. Then they go to consumer court or some court. The court will say you must give. Now these companies are not making a general order to give interest to all. They are waiting for everybody to go to court, and the court will give an award and then they will issue. Why they are not doing? Because they think that out of 1 lakh consumers, at best 1,000 will go to court. At least on 99,000 we will save money. I mean, this is the way we are loading the court with the
No, sir, and you very rightly said the government has to be proactive, and you rightly said that in fact the government is the biggest litigator. That is something that has been pointed out repeatedly. Mr. Ajay Dua, coming to you. And I want to ask this to you. The government has to be proactive, which means that the judiciary, the bureaucracy has to be proactive. When it comes to legislative drafting, you have to be proactive in terms of anticipating that you don't create such vagueness or problems in law, that there are avenues for further adjudication or dispute resolution that come up. But a lot of court orders often lead to closures of businesses in this country. So the stakes are very, very high. When it comes to proactive measures, what exactly is it that the government or the bureaucracy can do to avoid disputes of this nature reaching the courts? And I'm talking about big companies or big contractors and various other big infrastructure projects or development projects being stalled because they've gone into litigation.
Thank you, Risha, for having me on your discussion. I've greatly enjoyed the remarks of the senior judges, Justice Sikri and Justice Dhingra, as well as my colleague Sudhir Krishna on the subject.
Yeah.
All absolutely valid. I like to just answer in a couple of minutes what you asked me about the activism on part of the bureaucracy and the government as a whole.
Yeah.
Number one, let's be very clear that it is not possible to legislate on every aspect of life. In India we've taken to legislating. We have a written constitution, whereas say a country which ruled us past still doesn't have a written constitution. It's going by traditions and conventions and the laws made there. But we might legislate as much as we like, but still there will be so many aspects of life which are still left for interpretation,
Sure.
which are left for inclinations, and that is where, see, once a matter is laid, the bureaucrats and probably the courts to that effect, because the matter has been legislated, their discretion gets limited. They have to follow the letter of the law and the spirit of the law. The senior courts, even if it is not legislated, the constitutions called the constitutional provisions which guide the lawmaking in the country. Similarly, is the dilemma before the bureaucrats.
Yeah.
What has been legislated, whether it is pro-democracy, pro-growth, pro-development, is no longer in the hands of the bureaucrat, whatever level of government he might be. The question is, there we have to divide it between the legislated matters and the ones which are not legislated, and our lots of social aspects of life have not been legislated, and it's virtually impossible to do that. So that is where the activism of the courts as well as the activism of the bureaucrats, the civil services would come in.
Yeah.
That they have to be, and those aspects which are not legislated upon, that they are pro-growth, they are pro-poor, the so-called, the senior judge, Justice Sikri had mentioned about welfare state, etc. Those are matters which you can enforce and bring out your personal inclination and your bent of mind. And that is desirable in a country as large, as poor, diverse as we are.
Absolutely.
Moving on is the aspect that the matters which are legislated, though how does one handle those? And I think the discussion which Justice Dhingra brought out and then Sudhir has followed it up is how to expedite matters which are legislated. Can we give a higher priority to economic matters? Is it vis-a-vis social matters like the one which he referred to currently before
the Supreme Court? Yeah.
So I am saying there that there are ways out have to be evolved. 75 years, all right, fine, it may not have been done. The fact is, economic courts are a must at every level, may not be possible in the Supreme Court, but every high court must, and courts below that must have matters which, if they can be rotated, the benches will get rotated.
Yes, sir. And specialized court is something that has been a discussion that has been going on in the judiciary as well.
Happen, Anusha, their priority, they don't get mixed up with other matters. And the other resolution matters, the kind of things which Sudhir mentioned and Justice Dhingra mentioned, that when you have provided for arbitration in a contract, it is very, if the award has gone against a party, bad luck.
It must be enforced. Enforceability. I'll give the last two word to the learned judges. Justice Sikri, you opened the debate. I want to put all the points that the others have said, and I'm sorry to give you very little time here. But there's a buzzword which is often used here. It's called judicial activism. I don't like it as a student of law, and I'm sure the judges don't. But this is, for the lack of a better word, an allegation which has often been put on judiciary. How do you see that, sir?
You see, I think it's a very pertinent question which you have put. And I must, before that, say, we are talking about, and the narrative which you mentioned in the beginning.
Yes, sir.
Of course, prioritizing of the cases, and there should not be delay in the cases. These are some of the factors. But most important aspect in this matter is, or in the whole scenario is, that as I said, what should be the approach of judges in deciding such cases? Now, here comes, you are right, the question of this is always comes up of judicial activism. I
Yes.
would say that yes, we have the I mean principle of separation of powers, where all the three states of the wing are given their respective powers. Judiciary is here to decide the cases, but at the same time, judiciary is the last arbiter
Okay.
whenever there is a dispute of this nature.
Okay.
And in the context in which we are discussing this subject,
Yeah.
I may say here that we have to draw a line between judicial activism and judicial pragmatism.
I'm going to take away the keyword pragmatism here. And I'm sure the question that I've asked about judicial activism warrants a completely separate discussion altogether with all the learned men that I've had on the broadcast. That's all the time that I have, but it has been a fascinating discussion. And minds like yours are the key minds that are going to decide the judicial, legislative drafting of the country, how we can have better expertise at key forums in our country. Transforming India is the growth story that we're talking about. I thank all the panelists for joining us on the broadcast. Thank you, gentlemen, for sparing out time and being a part of this discussion. We'll continue bringing you more such conversations on this very platform about transforming India and boosting India's growth story. It's a wrap. Thank you for watching.